Good afternoon, everybody, and welcome to December 2nd. Welcome back. I hope you had a wonderful holiday, a really great time with your family. I hope you had a great Thanksgiving. Thanks for joining me here today. There was a little bit of a confusion about whether this was at 12 o'clock or 1 o'clock. We had a lot of people jump in at 12 while we were getting ready. Hopefully, I stepped in. I said, hey, we're actually starting at 1 o'clock. So I hope you're here and joining in. And I see more attendees keep popping in. So welcome to the Year in Review. Welcome to the Year in Review presentation. Today is December 2nd. My name is Greg Lois. I am the managing partner of LOIS Law Firm. And we're here today to talk about the biggest and most important cases that were decided in New Jersey workers' compensation law. So thanks for jumping in today. We're going to take a look back at 2024. And as I do this, I have to share with you some of my thoughts and my predictions for what's going to happen in 2025 as we continue to defend these cases throughout the great state of New Jersey. So I'm going to talk first about some significant case law decisions that will impact our practice and the way we defend cases going forward. I'm going to talk about some statutory changes as well. And I'm going to provide my opinion and update about medical provider claims. In today's presentation, in the handout, all of the cases that we're going to talk about, these case law decisions, and there's 3 of them that I selected that I thought were interesting or useful to discuss or will have an impact on the way we practice going forward. In the presentation today, if you're joining us live, they are in the presentation handout. So the actual case law decided by the New Jersey State Appellate Division. And just as a quick reminder, decisions of trial court judges in New Jersey are not binding precedent on other trial court judges. And interestingly, in some of the case law that we're going to talk about today, in fact, the one I think is going to be most interesting, the judge did make reference to unreported decisions. So let's jump in. Let's start talking about these cases, which we think are going to have an impact on us next year. So the first one I'm going to talk about is called Soto versus Hoosier Care Incorporated. This case was actually decided by the New Jersey Appellate Division on December 11th, 2023. And you're saying, but wait, Greg, you promised us 2024 cases. Well, this one was decided actually right after our last year in review presentation that we did last December. So this case actually was decided a week after I gave my year in review. And I do think it's going to be an important case and one that's going to help us understand the intersection between temporary disability benefits and workers' compensation law and unemployment. So in this case, the New Jersey Superior Court reviewed the decision, the trial decision of the Workers' Compensation Court. And remember, decisions of the New Jersey Superior Court, those appellate level decisions, those are the ones that are binding. Those are the ones that are actually an impact to practice. So here's the petitioner who was working in a home care facility. She was a CNA person, a certified nursing assistant, and she was sent out to various facilities and various people's homes to provide nursing care. So that was her original job. She got injured at work. She actually sustained an injury to her cervical spine, and she received a recovery. And I believe it was 15% for the cervical spine, and then 10%, I believe, for the shoulder. So an overall award of 25% of permanent partial total, or 150 weeks of compensation. So that's her initial award. She then goes back to work as a CNA, as you're allowed to do. Remember, New Jersey is an impairment state, so you can go collect your permanent disability award and go right back to work the next day, making more money, the same money, doing the same job, and you get to keep that award. That's how the system works in New Jersey. So she goes right back to work as a CNA. She then files a reopener. She files a reopener seeking an increase in disability. She says, my disability's increased. At that time, she was not working at the time she filed the reopener. She was actually collecting unemployment, and she was also a college student at that time. So the respondent in that case conceded that she had an entitlement to medical treatment, but not to temporary disability. And they actually send her back to a treating physician who provides a medical report saying that, yes, her condition has worsened in her cervical spine. She needs significant care. the doctor's report says, quote, she cannot work due to her symptoms, close quote. Now, there's no testimony about this alleged worsening. But again, the employer is conceding that she's entitled to medical treatment, but disputes that she's entitled to temporary disability. They say, wait a second, this is not fair. She's enrolled in college. She says she's taking courses in school, and she's collecting unemployment because she had been laid off from her position at that time. Now, the interesting moment is to collect unemployment, what do you have to say? You have to say, I am ready, willing, and able to work, right? So the employer brings out both of these arguments. One, you're a student, and two, she's collecting unemployment, so there was no wage loss because she wasn't working at the time of the alleged worsening. So that's what they argue. The workers' compensation law judge did award temporary disability benefits, saying, no, she didn't voluntarily leave the workforce, she was laid off. And the law judge went on to say, quote, but for her work-related injury, she would have been working elsewhere, close quote, and that her sole reason for being unable to work was the work accident, the original accident. Now, of course, we know that's not true because she did return to full-time, full-duty work after the original accident. She then collected a permanent disability award. She enrolled in college, and then she became subsequently unemployed. So again, the employer's argument is, wait, it isn't the disability that's causing her to be losing wages. It is the fact that she was laid off from her employment, and also the fact that she's a college student. We don't know if she's a full-time or part-time college student. There's the testimony, as I reviewed it, was unclear to me. So when you read this case, and there are cases that talk about this intersection of unemployment, of being unable to work because the employment has fired you or terminated you, that's Cunningham. There's a case called Temecki, which talks about whether you can be entitled to disability while you're going to school. And I think it's important to look at this decision and say, wait a second, you know, how important were the trial proofs and why wasn't the trial fully completed? The only thing that the judge of compensation based the award on was the testimony of the petitioner. And the judge ultimately found that she was entitled to temporary disability. Now, the interesting parts or the takeaways from this are, first, the petitioner was not working at the time she went for a need for treatment exam. And that exam, again, said that she could not work and that her condition had worsened. Now, what's interesting to me in this case is the impact this will have on other cases. First, the doctor's report was entered into evidence, but the doctor did not testify. And if I was cross-examining this doctor, I would have asked, hey, wait a second, do you know that she was going to college and how many hours she was going to college? Did you know that she was unemployed at the time you evaluated her? In other words, when the doctor's report says this person's unable to work, is that because she told her, I'm not working, right? Did the doctor just merely parrot that and put it in the report? And the other thing I would have asked is, are you aware of how often she's going to school? How many hours a week? Is it 25? Is it 30 hours a week? Is it 2 hours a week? You know, we don't know those things. And the last takeaway that I would take from this case is our admonition to generally not send the petitioner in a reopener claim back to the treating doctors. More often than not, they'll say, well, okay, we'll give some credence to the petitioner. Remember, they're going to err on the side of adding or offering more care. And in this case, it opened them up to a reopener award and an award for temporary disability benefits. So an interesting case because it included this fact pattern that we don't see that often. Again, the amount of schooling that the person was going to and the fact that she had already collected or was in the process of collecting unemployment. So I think this is going to make it murky or challenging for us to defend cases where the petitioner on a reopener makes a demand for temporary disability benefits. And there could be any reason that they're not working at that point. I think that petitioners' attorneys are going to rely on the decision in Soto to make an argument that if they're not working for whatever reason, the employer closed up, they went back to school, well, we're now entitled to temporary disability benefits. I don't think this case is that broad, but I do think that's how it's going to be utilized and argued by the other side. So this is the first case that I would say is going to have an impact on us going forward. All right, the next case I want to talk about is called Hughes versus Port Authority of New York and New Jersey. Let's talk about this case. This is another reopener case. In this case, the petitioner had a cardiac claim which was accepted as compensable and or found compensable. I'm not sure. It's unclear again from the appellate record. And by the way, I should remark that when we read appellate case law, we don't get to see the whole record below. We only get to see the little piece of it that is described in the decision that's issued by the appellate panel. But in this case, his underlying condition was a cardiac condition. He received a small award, in my opinion. I think it was 30% or 25%. It wasn't a huge award of disability. And then later claimed that his disability progressed. And on reopener, he now claims that he is permanently and totally disabled. The appellate division said that, by the way, the judge did find that the disability had increased. The judge said, you're not totally disabled, but your disability has increased. And again, the claimant said, I'm 100% totally disabled, and brought in experts who said that, and the respondent brought in experts who said the opposite. Now, the judge says, well, I reviewed a lot of testimony, and my decision is your opinion is your disability has increased. The appellate division comes forward and says, yep, we're not going to disturb that. That's the finding of the judge of compensation, and we're going to leave that alone. That's the judge's province, really, to weigh the experts. Most lawyers' takeaways from this is that the case reaffirms the deference given to factual determinations made by workers' compensation judges. But I think this case is important for another reason. It's because this mystery of how disability is determined is once again avoided by the appellate courts. Now, remember, in this case, the petitioner is the one arguing that the judge is wrong and that he's more disabled than the judge found him to be. The appellate court says, quote, contrary to Hughes' contentions, and remember, Hughes is the petitioner, the judge thoroughly discussed the evidence presented, made well-supported findings, and based his legal conclusions firmly on the evidence presented at the lengthy trial. And I bolded this part. I added the emphasis. While the judge did not specifically discuss his method for arriving at the percentage of Hughes' disability, it's clear his decision was based upon his assessment of the medical evidence and his conclusions that Hughes' disability had not drastically changed over time. Now, I think that that is hugely problematic, right? Here you have the appellate division telling a petitioner, yeah, we don't have any idea how disability is determined. In fact, we're not going to give you any guidelines as to what it is or how the judge should make their decision. But we're just going to say a workers' comp judge, they can kind of find anything they want as long as they write an opinion long enough to explain it. That's crazy. Again, the mystery, I call it the mystery of disabilities because in this state, in New Jersey, we don't rely on the AMA guidelines for determining disability. We don't rely on the American Academy of Orthopedic Surgeons or any other medical or expert body or scholarly body or scientific evidence or any other objective way for measuring disability, except for parties go out, they select experts of their own choosing. These experts are not impartial. They are not independent. They are selected by the parties. And then the judge makes a decision based on how they hear the testimony and what the facts of the case are. Now, the reason I say that the appellate division had just such an opportunity here to get into the mystery of this is because the appellate division could have said, look, judge, you've got to explain what this is based on. What is disability and what is it based on? Also interesting in Hughes is that Hughes already had a determination from the federal government, from Social Security, saying that he was totally disabled. So the appellate division addressed that. He said, quote, we find no significance that the Social Security Administration determined that he was entitled to disability benefits and was totally disabled. As the petitioner himself concedes, the administration has its own statute and applies different standards than the Workers' Compensation Court, close quote. So it's just, again, interesting to me, the appellate division recognizes that the federal government has standards and has published what those standards of disability are, but again, New Jersey does not, and it really is case by case, judge by judge, fact by fact. Their interesting moment here is that there is absolutely no curiosity at all about the standards for determining impairment that workers' compensation judges deploy. So again, I think this is one of those cases where what they don't say in the case is as interesting and maybe as important as what they do talk about. And in this jurisdiction, one of the biggest frustrations that I know my clients have, and I'm sure everybody faces, is what is disability? How is it determined? Is it really just rule of thumb and practical experience that we're deploying? And unfortunately, that's what it really comes down to in this jurisdiction. All right, let's move over to our third case, which is another one which is going to have a lot of impact on unsecured liens, or unperfected liens, I should say, in the Section 40 context. So the next case I want to talk about is called New Jersey Transit Corp. Versus Joseph. So here's an employee of New Jersey Transit who gets injured in a work-related accident, but there's also a third-party tortfeasor, someone else who actually harms him. And so, of course, under Section 40 of the New Jersey Workers' Compensation Law, he's allowed to go and file his third-party lawsuit to recover from the party that actually harmed him. And what this case does is sort of impact the timing and process of lien reimbursements in this state. And so I'm going to talk about a little bit of the paradox of that, or the paradox of a Section 40 recovery. So remember, under Section 40, risk transfer in New Jersey, the amount the workers' comp carrier recovers depends on the amount of the third-party civil recovery. By the plain meaning of the statute, and the statute, by the way, is quite easy to read. It's pretty short. I think it's 5 paragraphs that talks about who gets paid back what and when, right? And by the way, we love risk transfer, and I love Section 40 because it's pretty simple, it's pretty straightforward. But the statute says the employer's right to reimbursement is conditioned on the employee's recovery of any sum from a third-party tortfeasor. Well, that makes sense. The amount they're obligated to repay us is based on how much they have to pay us back, is whether or not they recovered more or less than the liability of the employer under the statute. And the statute doesn't say when the employer's lien must be satisfied. So in this case, New Jersey Transit versus Joseph, the third-party case settled for $14,000. At the time, the workers' compensation case was still pending, and the employer carrier had not paid out more than $14,000 in workers' compensation benefits. In fact, according to the decision, they'd actually paid out less than $7,000 or $8,000 in workers' comp benefits. But the permanency aspect of the workers' compensation case was not yet resolved. It was still open. So interestingly, the court ruling in this case was that there's no requirement that the employer's lien has to be paid following the immediate recovery from the third-party tortfeasor. Because remember, in this case, the petitioner received the $14,000 back from the tortfeasor, which was really his uninsured motorist policy, and he didn't have to immediately pay that money back to us, the amount that we had already issued. And the reasoning of the court was essentially because the workers' compensation action was not yet completed and the permanency aspect was not yet determined, that did not trigger or require him to make that reimbursement immediately. So when would the employer receive their third-party reimbursement or recovery under Section 40? Well, the answer is once they close and resolve their workers' compensation case. Now, I know that might sound strange, like how Greg, don't in most cases, as soon as they settle that civil recovery, don't we just go and grab back whatever we're entitled to? Usually it's 2/3 of that civil recovery, and then have a credit going forward against our workers' compensation case. And I say, yes, that's typically how it works. But in this instance, and as far as I can tell, this is a case of first impression on this subject, because the workers' compensation case was not yet completed, it was not yet determined if the workers' compensation carrier's amount spent was going to actually exceed what they recovered in the third party. The appellate panel said, no, you don't get any recovery until the workers' compensation case resolves, which sets up a bit of a paradox. What if the workers' compensation case never resolved or just stays open? Are we supposed to sit there? And the appellate division answered that by saying, well, what they could do is keep that money, that $14,000 he recovered, in his attorney's escrow account to be distributed upon the resolution of the workers' compensation case. So 3 cases, 3 interesting rulings over the course of this year, and all of them we're going to be applying to the way we practice moving forward. So that's case law changes. And again, those are just 3 I picked out as I think being some of the most interesting cases. Let's move over now to talk about statutory changes. What were the statutory changes that are going to impact you as a respondent or as an employer in the state of New Jersey? Well, the first one is, we do have a Governor Murphy, but he's lame duck. He can't run for election again. He's done. He's out. And so what he's been doing is allowing his friends who are state senators to be the acting governor for a day. Right, so they can say on their resume, I was the acting governor of New Jersey. So he let acting governor Nicholas Scuteri sign into legislation in August a new law that says the attorney fees in workers' compensation cases are increased as of the day, August 22nd, 2024, from 20% of the total award to 25%. This is the first time in almost 100 years that they've increased the amount of the attorney's fee. And we're starting to feel this immediately, right? Because when it was enacted, it didn't say for cases with dates of loss after August 22nd. It's all cases, and it impacts cases with dates of loss before the enactment. So if you're an employer of the state of New Jersey, your cost just went up 5% because the governor and the legislature decided to give petitioners' attorneys just a little bit more of a fee in these cases. So that's the first statute change that's going to impact us, and of course negatively. And the second one, and this happens every year, the maximum rates have increased. So effective January 1st, the maximum rate will increase to $1,159. And the minimum rate will increase to $309. The last topic I want to talk about in our look back at 2024 is medical provider claims and the politics of inaction. Okay, if you're doing this at any type of scale, and we're defending, by the way, hundreds and hundreds and hundreds of medical provider claims across the state of New Jersey, they're some of the most frustrating cases that you can possibly defend. Why? They continue to get second-class treatment by the Division of Workers' Compensation. Counsel for the providers, meaning the medical facilities and treatment providers, continue to file extra-jurisdictional claims. What's an extra-jurisdictional claim? Well, they love to file claims on behalf of treatment providers who provided treatment in New Jersey, but for workers' compensation accidents or injuries that occurred in other states, primarily New York. And as you know, I've been on this high horse now for a decade fighting those cases. And we're the only firm that got case level decisions, trial decisions, as you know, in 2023. And in fact, we won the trial level case that we rely on this in 2023. What frustrates us, though, is this continues to happen. Both these medical provider claims continue to get second-class treatment by the Division of Workers' Compensation, meaning they continue to move along at a very slow pace. And there's no new binding appellate case law on this. We keep winning these cases at trial, and you should be winning dismissals and getting no pays in these cases. But what I find is that counsel for medical providers continue to avoid trials and do not appeal it when they lose. And so what we do not yet have is an appellate level decision which addresses directly the abuse of the system in these medical provider claims. And again, I consider this almost political because there seems to be almost concerted action in not doing anything about this scourge. Roughly 1 in 5 of all the cases pending before the Division of Workers' Compensation are medical provider cases. And again, I get it. If I was a judge of compensation, and I understand the position of like, hey, I don't want to act like somebody's fee collector, or we're doing bill collection, and I guess they don't want to deal with respondents' arguments about particularly extraterritorial claims that are coming in more and more that we're defending. I understand it. They really want to take care of the petitioners who are actually injured and hurt and harmed, and that's where they put their focus. But this backlog of medical provider cases is very frustrating on every level. So if there was one magic wand I could wave and fix, it would be to draw some more judicial attention to these medical provider cases so that they could move more quickly. Okay, closing up. Our workers' compensation webinar series will resume next month in January. Our webinar series, you've already seen the agenda and the schedule for next year, and what you'll see is that it's going to follow very closely the practice guide that I write for LexisNexis, which is the #1 legal publisher in the world. I write the book for them, the handbook, with my co-author, Richard Rubenstein, and every year we update and use this book as our webinar sort of spine. This is sort of the curriculum that we're going to follow together. So I hope you join me over the course of the next year as we go through these topics one by one. All right, I saved a little time at the end for some questions. I'm going to open up the questions panel and see if we have any that have arisen so far. So far I haven't seen any questions pop up, but I'm going to open this panel and just give everybody a second. If you have a question for me, please feel free to ask it. I love answering questions, and I presume that's why you come to these things. They're interactive, and you can ask me questions live and see what my answers are. I also think it's fun because I know some of the attorneys that work here like to come to these webinars and try to ask me questions to stump me. Although as I look through this group, I see Kyle, I don't see a bunch of the other ones. So maybe everyone's giving me a break today, maybe for the holidays. That's nice. Thanks, everybody. All right, so I don't see any questions, so I'm going to move on into my last and final slide, which is I hope you have a great holiday season, a Merry Christmas, a Happy New Year, and I'll see you in January as we begin again our exploration of New Jersey workers' compensation topics together. I'll see you next year. Have a great one, everybody. Thanks for joining today.